You tell them that 170 people are online, the entire Mvskoke watching, but don't be nervous.
Entire.
Yeah, the Mvskoke broadcasting it to their tribe.
You'd be surprised how many times I'm interested in. Yeah.
They want to see that.
Do they typically use the long form? Do they typically use the long form, your AAP voluntary?
There's not really a short form much anymore. Look, it's senior citizen, so yeah, it's just the same.
Okay.
But with software, it doesn't matter.
Yeah.
The problem with software. is Nobody figures it
Yeah.
out. Oh.
Thank you. Good morning, everybody. Bene. Thank you for joining us this morning. My name is Derek Beetso. I serve as Professor of Practice here at the ASU College of Law. I also serve as Executive Director of the Indian Gaming and Tribal Self-Governance Programs. We are excited today to bring to you a presentation called Sales Tax and Online Sales Tax Issues in Indian Country. I have been working with the students to my right here for the whole semester on these issues, and we're excited to present our findings to you all this morning. Before we get started, though, let's go over a few housekeeping items for those of us that are joining online. If you look at your screen, you can see what your screen should look like in today's Zoom webinar presentation format. On the bottom right-hand side of your screen, you should see a question and answer box. That's how you can participate in today's session. You guys can add questions into that box there, and you can upvote questions. If you think questions are more relevant and you want to hear more about those questions, please feel free to actively participate in that. And then at the end of today's session, when we get into the Q&A format, we'll go to your questions that you guys have put into the queue, and we'll take as many as we can for as long as we can today. But with that being said, we want to go ahead and introduce myself and my co-professor, Professor Irving, and then we'll introduce our students, and then we'll get going with today's agenda. Also, we want to provide a quick disclaimer here. Everything that are in your materials and everything that were presented today is intended to be for public education purposes only and not intended to be legal advice at all. If you guys run up against any legal questions, we advise you guys to reach out to an attorney that specializes in this area and follow up with them. As I said at the outset, my name is Derek Beetso. I've been the professor working on this tax research cluster with the students to my right. This has been a saga in the making. I taught Indian tax probably a couple of years ago, and I haven't had an opportunity to teach it since then, but I've had two 3Ls who were very consistently asking me, Amani Hicks to the far right and Morgan Oakes, the second to the right, to teach Indian tax. And so what I did was, because I had a heavy load this semester, I taught it as a research cluster, meaning that I only met with the students several times throughout the semester, and I gave them research projects and assignments. What was really kind of fulfilling about this project is that they came to me with areas of interest that they wanted to study and that they wanted to look into more detail on. And so the paper that you guys have, for those of you who are online, you should have received a link to a PDF document. And for those of you in person, the paper that you have in your folders is a result of all the research that they've done this semester. I'm very proud of the work that they've done. And so I just want to keep my remarks short so we can get into the stuff that they've done. But I'm going to turn it over real quick to my co-professor here, Patrick Irving, to give a couple of remarks. Thank you.
Thank you, Derek. And I've been really happy assisting with this, but Derek's done the lion's share of the professor work. The students, of course, have done all of the student work, and the result is very admirable. And it's always for me to be here at ASU. I'm an alumni myself. I have a brother and a son who are also ASU law grads. My first work with Indian law was actually a seminar that was put on by the law school when I was an undergrad at ASU in 1977. So it goes way back. And I actually, as a student here, took Indian law from then Professor Canby, who sort of initiated the Indian law program here as a professor. I think I was probably the last Indian law class he took before he went on to the Ninth Circuit. So as a full-time professor back in 1979 or 1980. And I've actually taught here Indian law and taxation. In fact, the first time I taught it in 2006, Derek was one of my students. Professor Beetso was one of the students. And I think no one was more surprised over the years than that the information he learned proved to be useful than him, because he went back to Washington and found that taxation scared off a lot of people. So the fact that he was not scared about it led him to do some very interesting things and work on issues with Congress, with the Supreme Court and amicus briefs and a whole variety of things. An important thing to remember about taxation is that it affects everything, that it comes up in very odd context. And there are many lawyers who start out to be civil rights lawyers or real estate lawyers or economic development lawyers, and they find that they have to spend a lot of time on taxation because it has implications there. So part of the purpose of teaching at the law school is not just for the students, but also for the community. So something like this is very valuable, to members of the community and people out there trying to deal with issues where taxation may come up, and if you ignore it, will come back and bite you. And so the students and the information they're presenting will be very helpful to people who may not think of themselves as tax nerds or tax professionals, but they have to recognize the concepts. And then, as Derek says, ask more questions of more specialized people and make your economic development projects be better, make your real estate projects be better, make how you treat people and run your governments be better. So very pleased to be here. The students have put together a very valuable product, and I think the seminar or the presentation today, along with the work product, which will carry forward into the future, will be very valuable. So thank you.
Appreciate that, Professor Irving. I'm going to go ahead and turn it over to the students now to come up and introduce themselves, and then we'll get going. So thank you for your time. Thank you for everybody joining online. Thank you for everybody that came this morning. We really appreciate your attention and your interest in this area.
Hi, NEPI. Good morning. My name is Michaela Bledsoe Downs, and I am a 2L. I'm also Chickasaw and Winnebago. They're going to stay seated, and they'll use the mics to introduce themselves.
Name is Morgan Oakes. I'm a citizen of the St. Regis Mohawk tribe from upstate New York, and I'm a 3L.
Siona God. My name is Sam Phillips. I'm a citizen of the Cherokee Nation. I'm a 2L. I'm from Tahlequah on the Cherokee Nation Reservation.
Hi, everybody. My name is Hunter Mallinger. I am an enrolled member of the Nome Eskimo community in Northwest Alaska and descendant of the Inupiaq people. I am a second-year law student here at ASU Law.
Good morning. My name is Imani Hicks. I'm enrolled in the Pechanga Band of Indians, and I'm a 3L.
All right, so thank you all for joining us today. Just a couple of more housekeeping items. Please silence or power off all of your cell phones. If you need to use the restroom, there are some up on the second level right in that hallway. Or if you take the hallways around right to the back, there's bathrooms right in the center for you. And then please save any questions until the end. We'll have a dedicated section for it, and we'll be able to pass the microphone so everyone here can hear the question in addition to our online participants. We're excited to share our learnings with you all. So let's get started. Again, just a brief overview of the agenda for today. So sales tax in Indian country. The Indian Commerce Clause grants Congress the power to regulate commerce with tribes. It establishes the U.S. government's authority to regulate trade and economic activities involving tribes and, in most cases, limits state power from regulating commerce with tribes. The issue of dual taxation of non-member economic activity by tribal and state governments is incredibly prevalent in Indian country. How we understand taxation in Indian country remains inconsistent in case law and scholarship, which impacts how tribes generate revenue. So what is dual taxation? Dual taxation occurs when a state or local government taxes the same activity as the governing tribe. Businesses operating in Indian country sometimes have to pay both tribal and state or local taxes, which discourages them from conducting businesses on tribal land, reducing economic opportunities for tribes. As a result, dual taxation can hinder economic growth for tribes, weaken tribal sovereignty, and create legal conflicts. Now, Sam and Morgan will address the 3 different taxing sovereigns.
Thank you, Michaela. Welcome, everyone. So I'd first like to start out talking about federal Indian law, or federal law as it pertains to taxation in Indian country. Tribes have always had and continue to have powers to self-govern. This is not questionable. It's been clear since the founding of the United States, as evidenced through the numerous treaties between the United States and the several tribes, and even codified in the United States Constitution, which has clearly set apart tribes as sovereigns. Now, with that, outside of this, the Supreme Court has also determined that Congress's power to regulate tribal affairs is plenary and exclusive. So both the self-governance of tribes and Congress's Indian affairs powers have been affirmed as early as the earliest Indian law cases in Cherokee Nation v. Georgia and Worcester v. Georgia. It's again been reaffirmed time and time over throughout the history of the U.S. and even in recent cases such as Holland v. Brackeen. Now, in Holland v. Brackeen, the Supreme Court specifically acknowledged how clear case law has been in this matter, and that the case law leaves little doubt as to Congress's powers in tribal affairs, and those powers supersede both tribal and state authority. Now, with that, part of Congress exercising these powers has been through numerous acts. One very important example being authorizing the Secretary of the Interior to hold land in trust for the benefit of Indian tribes or individual Indians. Whether this has been achieved through the authority of the Indian Reorganization Act or separate congressional acts establishing reservations or even Indian land claim settlements, each of these have been an exercise of Congress's plenary and exclusive power to regulate tribal affairs. Now, specifically as it regards land, the trust character of the lands is extremely important to our conversation because it creates a corresponding trust responsibility exclusively administered through those federal powers, which sets it aside from any state authority. Now, with that, the result is that state laws are generally not applicable to Indians on an Indian reservation. That, again, taking the trust and holding it through those federal powers sets it outside of the reach of the state. Additionally, because the court has found states have no power by taxation or otherwise to impede, burden, or in any manner control the operations of the constitutional laws of Congress, for that reason, state law only applies on a reservation when Congress explicitly says so. As a result, if a state does attempt to tax activity on the reservation, even where non-Indians are involved, that action may be prohibited. So this brings us to the question of state law and taxation in Indian country. More specifically, when does it apply and when is it prohibited? So when we talk about determining if a state tax is valid, the courts look closely at where the incidence of the tax falls, or put more simply, who bears the legal responsibility for paying that tax. This brings me to what you'll see as kind of a running theme through our conversations. We referred to it in class as the 5 W's. So we need to know who is the taxpayer, the actual person responsible for paying that tax. What's the activity being taxed? Where is it happening? Where is it taking place? And when? So what law applies based on when that tax happened or when the transactions being taxed happened? Now, as far as our conversation goes, we're looking specifically at economic activity or transactions on the reservation. So those last 3 of what, where, and when are pretty determined for our purposes. So today, what I'm going to focus on is the who. Excuse me. So Supreme Court precedent prevents states from taxing transactions where the responsibility to pay the tax falls directly on a tribe or an individual tribal member inside of Indian country. We know from our discussion on federal law that state law generally doesn't apply to Indians in any Indian country, but we also know from the Supreme Court precedent that this has been affirmed time and again. This often is referred to as the categorical exclusion. You'll hear us refer to that a couple of times today. So if the economic activity exclusively involves tribes or tribal citizens and it's within Indian country, states cannot tax that. It is a categorical exclusion. But states may be able to apply taxes to transactions involving non-Indians or non-members. Just a note, when we say non-member Indians, those are tribal members that are not members of the governing tribe of the reservation that they're on. For tax purposes, the Supreme Court has treated non-member Indians on the reservation the same as non-Indians. A simple example of this would be if I, as a Cherokee Nation citizen, went to any of the reservations here and conducted a transaction that may be taxable by the state. That state taxation, however, in that kind of scenario would be subject to very specific barriers. These barriers have been most clearly set out in the Supreme Court case White Mountain Apache Tribe versus Bracker, which has become the controlling case for analyzing these scenarios and balancing the tribal, federal, and state interests involved to resolve any tax disagreements. Before we get into the analysis itself, I'll give you a quick background of the case. So in Bracker, is what I'll refer to it, the White Mountain Apache Tribe contracted with Pine Top, which was a non-Indian owned company, to harvest and transport timber. Within that, though, the operations themselves were overseen and controlled by a tribally owned organization. The subcontract with Pine Top to do the actual felling and transportation of the timber to sawmills on the reservation was done under a federally approved contract. All of the work that Pine Top did for the tribe and any operations between the two were specifically done under strict federal regulations that oversee the harvesting of timber on reservation land. So with that, the operation had been going on for several years. Then the state of Arizona decided that they were going to impose a motor carrier tax and a fuel tax on Pine Top's activities, which again, were solely conducted on the reservation. So Pine Top paid the tax under protest and then brought suit to enjoin or try to stop that tax. One of the key factors here is that in that agreement between the tribe and Pine Top, the tribe agreed to pay any taxes that the state placed on Pine Top's activities. So this created a very strong tribal interest in the outcome of that case. So in that manner, the tribe stepped in, intervened in the case, and became a party to the case as well. The state courts of Arizona upheld the tax and eventually worked its way up to the Supreme Court. Now, with that, when the court was looking at whether or not this tax is preempted or is forbidden, prohibited by federal law, they described the federal regulatory scheme that it was working under, that was overseeing those daily operations, as so pervasive that the BIA had to have day-to-day management to make sure that it was being done properly. The resources that went into it were all provided by the tribe because they were all on reservation, or were provided by the federal government through the BIA managed roads and the overseeing of the program. So the daily oversight that required, the court saw as so pervasive and so involved that any state interference threatened the main point of that regulation, which was to make sure that the tribes were the sole beneficiary of any of those resources being extracted from their land. So when we get to that and we talk about that and talk about balancing those interests and seeing, the court in Bracker called for a particularized inquiry into all of the interests at stake to determine two things. One, if a state tax violates a federal law, or two, a state tax infringes on the tribe's inherent rights as a sovereign. And although these two barriers are connected, they're independent, and the court pointed that out because either one on its own can be enough to render a state law inapplicable to economic activities conducted on the reservation. Okay. So under the Bracker analysis, state taxation on reservation economic activity is disallowed if it infringes on or is incompatible with federal and tribal interests reflected in federal law. Again, in this case, that scheme that was overseeing timber and the harvesting of timber was so pervasive that any tax or burden that the state would have placed on either Pine Top or the tribe was precluded because it threatened to kind of disjoint the whole situation. And at the most general level, the state's taxes were incompatible with the federal and tribal interests because, again, the whole point of that scheme was to make sure that the tribe received the benefit of whatever profit the land was capable of yielding. So this holding that a state tax is preempted by federal law, where federal government has undertaken comprehensive regulation and the federal scheme would be threatened by state taxes imposed, has become kind of that first barrier that a state must overcome in the Bracker analysis to determine whether or not their tax is valid. However, if there is no federal scheme that would prevent it, or the federal scheme is not as detailed, that state tax may still apply if the state can show that their own interests are sufficient enough to warrant the intrusion. To make that determination, the reviewing court looks to what we refer to as the second barrier. So the second barrier requires courts to consider the extent of the federal and tribal regulations governing the taxed activity, whether the economic burden of the tax falls on the tribe or the non-member individual or entity that's conducting the business, and the extent of the state interest in justifying the imposition of the tax, which cannot be the sole purpose of raising revenue for the state. There must be more involved in that. So in overcoming that second barrier and showing the court that the state's interests are sufficient enough to warrant that type of intrusion, it's not surprising that the balancing that the court does in this analysis results in very unpredictable outcomes. Some courts have applied Bracker to reject state tax efforts, while others have applied Bracker to uphold them. We talked about Bracker, and that's an example of using the analysis to forbid the state tax, but one notable example of the court upholding the tax comes from Cotton Petroleum Corporation v. New Mexico. In Cotton, the Hickory Apache tribe in New Mexico had oil and gas leases on their reservation. Cotton Petroleum obtained some of those leases and were producing oil and gases under them. Now, so we have similar facts between Bracker and Cotton in that oil and gas leases on reservations are also governed by federal law. But here, those regulations were set up for the sole purpose of making sure that tribes could enter agreements like this to lease out that ability in production and then tax it and make revenue from it. Whereas in Bracker, everything was so controlled that it literally took daily oversight from the BIA. That wasn't necessarily the case in Cotton and that regulatory scheme. So then that kind of took care of that first point of what's the extent of the federal and tribal regulations governing the activity. So there, the state could potentially still show an interest. So then the court looked at where's the economic burden falling? Who's providing services? Who's actually putting out money to make sure this can happen? That's where the things start to really differ. So whereas with Bracker, all of those services were being provided either by the tribe or the federal government. In Cotton, the court pointed out that the state was actually providing a lot of those services, maintenance for the roads going in and out. The safety regulations for that type of activity were overseen by the state. So these additional interests started to kind of weigh more in favor for the state versus the tribe. So when the court looked at that and that the fact that New Mexico was providing these substantial services related to the taxed activity, the court in that case said that those interests were sufficient enough for the tax to stand. So when we get to that, that's how we see how easily that can start to shift. So that kind of leaves us with a question of where's the line, right? At what point is the tribe doing enough and providing enough services that the state is, again, cut out and not accessible to that taxation? So to discuss that, I will turn it over to my colleague, Morgan.
Good afternoon, everyone. Okay, so we start with the premise that the tribe has the inherent right to tax. But when the state tries to tax, it frustrates that scheme, causing the issue of dual taxation. And so the way I like to imagine it is on one end, we have Atkinson, and on the other end, we have central machinery. And those are the two end zones that we're sort of working with here. And in the middle of those two end zones, the court will use a lot of Bracker factors to determine if the tribe or the state have the right to tax. And in Atkinson, there was a non-Indian on fee land within the reservation, and the court held that the tribe couldn't tax. And the court looked at the two Montana factors, the two Montana exceptions and said that the tribe didn't meet either one of those exceptions. It didn't have a consensual relationship with the tribe, and the political health, welfare, and integrity of the tribe was not at issue here. And on the other end of the scale, we have Central Machinery. And Central Machinery, everything was done on reservation. The contract was negotiated there. The contract was entered into on the reservation. The only thing that came from off the reservation was the tractor. And so even though the tax fell on the non-Indian entity, because of all of those other factors, the court determined that the state could not tax. And so in Central Machinery, we have what I like to sort of conceptualize as a categorical exclusion of states. And it stems from the principles of inherent sovereignty in Marion. And this solidifies the tribe's inherent exclusive right to tax without state intervention. And in Central Machinery, the sales tax, or the transaction privilege tax as it's known in Arizona, always falls on the consumer, that incident of the tax. And so the tractors were sold by a non-Indian company, but the sale at issue was to the tribe. And that company didn't need to be registered under the Indian Trader Statute because the mere existence of the Indian Trader Statute alone preempted the field. And preempted the field is just a fancy way of saying that because this statute existed, it took up so much space that it sort of cornered the state out of the taxing process. And so the only two sovereigns that were allowed to tax were the tribe and the federal government. And so the state can reach into the reservation, but only when the purchaser is non-Indian or non-member Indian. And so the factors that the court used in Central Machinery illustrate the tribe's taxing authority here. And this will become important later on if the tribe wants to start negotiating tax compacts, which I'll talk about later on. And so the two main ideas here is that Central Machinery is a categorical exclusion, removing the dual taxation issue from the tribe's calculus if it decides to tax. And second, tribes can work in that gray area, those BRCA factors in between Atkinson and Central Machinery, laying the groundwork to get those BRCA factors on your side early. And that's what I'll touch on in the compacting section. And so next, Michaela will discuss when a state may impose burdens on Indian businesses to collect and enforce tax.
Thank you, Morgan. As she mentioned, I'll be discussing some infringements on tribal sovereignty that are caused by dual taxation. So we've determined that the state tax applies, and we're kind of asking ourselves now, what does the tribe have to do? So the Supreme Court has ruled that a state may impose what we call minimal burdens on Indian businesses to help collect and enforce the state tax. Some examples of these minimal burdens include affixing tax stamps on cigarette packages, as shown in the picture above, and record keeping. While these minimal burdens are hard to enforce, they nevertheless represent infringements on tribal sovereignty. As I mentioned in the beginning of the presentation, there are other limitations caused by dual taxation, especially towards sovereignty, tribal sovereignty, and Sam's going to discuss those further.
Thank you, Michaela. So when we're in that world of dual taxation and we know for sure that the state is allowed to tax the activity, we get in the situation of how does that realistically impact the tribe and economic development? So with that, dual taxation often discourages tribes from taxing certain goods or certain activity in efforts to attract outside investment and remain competitive in economic markets. This generally manifests as tribes either foregoing or limiting their own taxation authority. Foregoing tax altogether makes tribes rely solely on revenue from leases of lands, business licenses, and other fees that may be incidental to a non-Indian business doing business on the reservation or on tribal lands. For obvious reasons, this burden places the tribe at a disadvantage when it comes to raising revenues for their own government programs and their own regulations. Now, while we would prefer not to completely forego it, that puts us in a really kind of weird situation where we need to look at possibly limiting that tax to stay competitive, right? A business isn't going to come to the reservation and invest money there when they know their consumers are going to have to pay a higher tax than they would 15 minutes down the road. So when we look at that, businesses have to consider whether opening locations on tribal lands would actually be too much of a risk. Are they going to have a consistent and steady business stream? Are they going to be making enough money to justify the kind of seed that they have to put into it? When they're doing that, it puts tribes at a disadvantage at the negotiation table, right? So when they're in those very early stages of saying, yes, come lease this land, we'll work with you to make sure that, you meet the requirements for our licenses and you can do business here. As we are all very aware, most reservations are deserts for resources. So in theory, businesses would be very interested in coming there because there's not a lot of competition. But when you think about the fact that, is it going to make sense to buy my groceries here or to buy the goods that I need here when I can drive 15 to 30 minutes away and not have to pay as much in taxes? That's where it gets really tricky. So to avoid this during negotiations, businesses will often ask the tribe or even demand that the tribe not tax any higher than what the closest off-reservation town or county tax is. Now, when we're in that situation of the state is already applying their tax, that means we have about this much room left for the tribe to fill up the space. When we look at city and county taxes, that actual tax rate is usually less than 1%. So you then have a tribe who's expending resources to provide services for businesses on the reservation, but the state is taking up so much space that the tribe can only recover usually up to 1%. It's more frequently less. Now, in doing this, while the tribe's only getting 1% of that sales tax, the state's still enjoying like 5, 10%, depending on where you're at. So that makes it really hard for businesses to justify putting that capital into a business where they're not sure if they're going to have a steady consumer stream unless the tribe agrees to either completely forego that taxation or to completely limit it to not going above what a city or county would tax. Now, with that, you would think, okay, well, it is on the reservation. Is this tribe kicking back any of that state tax like we would see in some distributions to states or from states to cities or counties? That's not the case with tribes. It's not the case with tribal communities or reservations. Those state taxes do not return to those tribal communities. So the impacts of the lessened revenue stream from not being able to tax the amount that the tribe should be able to tax under their authority because the state is filling up that field is reducing how much they can support in new government programs or functions. So we still end up in this situation where we may have a store on the reservation now where our people can go and get groceries a little more accessibly, but we still can't provide all of the other general welfare systems that our tribes need because of that lack of revenue and because of the restriction that the state tax puts on our ability to raise our own revenues. So where does that leave us? And what is the best path forward? To discuss this a little bit more, I'm going to turn it back over to Morgan.
Tax compacts. So tax compacts add they add a lot of certainty to a very uncertain area of the law. And according to an article published in 2023, more than 200 tribes have entered into tax compacts with 18 states. And tax compacts are like sovereignty. They can be used as a sword or a shield. And what I mean by that is they can be used offensively to add certainty to a very murky area of the law and invite development. And they can be used defensively to fall back on as sort of a codification of that already existing state law. And so tax compacts is one option and legislation is another. And federal legislation is unlikely but not impossible. Given that Congress has plenary power over tribes, Congress can legislate the means, manner, and scope of the state's taxing role. However, a congressional fix is unlikely and would take a lot of time to orchestrate, but it's worth noting that Congress has done so in the past. And they did so with the Indian Gaming Regulatory Act, commonly referred to as IGRA. And so the Supreme Court decided Cabazon, and then a year later, that spurred the IGRA framework. Congress enacted IGRA as a means to regulate the relationship between tribes and states in entering into Class 3 gaming compacts. And Class 3 gaming compacts are a bargained for exchange. And what that means is everybody sort of gives up something to enter into this negotiation. And Professor Beetso reminded me that there's a very famous saying that if everybody walks away from the negotiating table unhappy, maybe it's a good deal. And so in the gaming context, more recently, we've seen that gaming compacts have had a lot of unreasonable asks. And most recently, the California compacts have included things like child care payments, tobacco payments, CEQA provisions, and absorbent environmental provisions. And so the thing with IGRA is, though, that when you submit your compact to the department, they have the authority to approve, disapprove, or deem approve. And that allows the government to sort of assess and draw a hard line on what is permissible and what is not permissible in these compacts. Now, because there's no legislation in the tax area, there is no hard stop of that federal government closing the door and saying, no, this is disapproved. So that really puts tribes in a shaky position because the only people that can negotiate these compacts are the tribes and the states. And if the terms are unfavorable, it's up to the tribe and the state to negotiate a better deal. And so tribes should be wary of things that don't necessarily fall within the four corners of a tax compact. If it's not a subject of tax, an issue of tax, then maybe it shouldn't be in the tax compact. And so tax compacts. Tax compacts allocate the power of tribal and state tax and how that's going to occur on reservation. And so, as I said before, tax compacts add a lot of clarity, and that clarity will in turn invite business development. And so what does the state have its sights set on in the compacting process? Well, it probably is thinking that it wants to tax non-member Indians and non-Indians at places like casinos, resorts, resort complexes, and other economic development businesses of the tribe. And they'll likely come to these negotiations using cases like Colville and Cotton Petroleum that really assert their taxing authority over the tribe. How do tribes combat that? Tribes can combat that by making sure their federal interests are shored up before they go into these negotiations. How do they do that? As I mentioned before, there's Atkinson and Central Machinery, and those are the two sort of field endposts of the taxing world, and everything in the middle is Bracker. And so tribes can shore up their federal interests by making sure those BRCA factors that the court looks at are on their side. And so they can do that by writing tribal laws, tribal codes, making sure that regulations are in place, having a tax law that talks about the allocation of jurisdiction, the allocation of tax, who's providing these governmental services, where the tax is going, all of these things that courts will eventually look at to make sure that the tribe and that this tribe can exclusively tax. And those are the things that will put the tribe in a better position to push back against the state in these negotiations. And so two examples of that, Washington State, they have a statute that outlines how taxing will happen within the state and tribes. And that is particular with cigarette sales. They talk about the stamping process, as Michaela said, serial numbers, when the tax is imposed, who will collect and remit the tax, when the contract will renew, and those sorts of things. And second, tribes have provisions where the state can remit tax to cover certain non-member purchases. So that would look like the tribe collecting a large amount of money and then remitting that on a case-by-case basis. Or if you have a tax compact, a certain percentage of that could be remitted. And so just to recap, although tax compacts present their own challenges, they may be a good option for tribes to provide more clarity on a sort of murky area of law, particularly in the tax setup. And so next, Sam will discuss bolstering tribal federal interests through strategies and structures.
Thank you, Morgan. So because tax compacts and legislative fixes take time and favorable governments on the other side of that compact, we wanted to talk a little bit more about the considerations for how tribes can bolster the tribal and federal interests, like Morgan was saying, and what that looks like through strategic business structures. Now, while ultimately we are talking about the tax that's placed on the transaction once the business is running, there are ways that tribes can move into that space intentionally that moves those BRCA analysis and factors more into their favor. So the thing that we've kind of decided in our research that seems to be one of the most important things to do is to consider those BRCA factors in the earliest stages of planning, whether that's starting your own business venture as a tribe or contracting with a non-Indian owned business. The BRCA analysis needs to be at the forefront of those planning stages. So what does that actually look like? In the case of a tribally owned business, that could look like a tribally chartered corporation or a tribal LLC. Now, there are differences there, and some would argue that a tribal LLC would be more beneficial because it's more legally protected because it's directly placed under the tribe. Whereas a tribally chartered corporation, while it is wholly owned by the tribe, it is still separate. So when you're thinking about these things, you really have to think about what looks best and what makes most sense for your own infrastructure and needs, and are there benefits to one over the other? Now, when we're also looking at other considerations for, say, contracts or agreements to lease land to non-Indian owned businesses, this is where the tribe can really position themselves well and strong in that BRCA analysis by making sure that in the lease there are choice of law provisions that place those businesses that are on the reservation as operating under tribal law. You know, this brings any disputes, anything like that, under the need for that business to exhaust efforts in tribal courts before they can take it elsewhere. Within that, robust tribal taxation frameworks, as Morgan mentioned. Is this something that a tribal code alludes to the ability of the tribe to tax, or is it a very well thought out and specific framework that talks about what types of taxation, how much that tax would be? The more detailed it is, we get back to those factors considered in Bracker and Cotton of how extensive is the federal and tribal regulation and the interest involved in that. When we're also talking about partnering with other businesses, does that look like a true partnership? Is it more beneficial for the tribe to have 51% ownership and structure that in a way where they're also making management decisions? So then they're removing that kind of one step away of, well, you're just the landlord. All of these decisions, the business itself, that's still a non-Indian business. So these are things that when you're in those early stages of planning can all move those Bracker factors closer to you. Morgan also mentioned, again, the services. What services are the tribes providing? Are you leasing the land to a developer that's then doing subleases? Because that can change those patterns, that can change those factors. If you're acting as the master lessor, that puts you in more control. That means if you're contracting with an outside power utility to power the entire complex, you are providing those services. So those are all things that could just slowly inch further and further on that Bracker analysis towards that federal interest being preempted. Because again, if the state is not providing those services and the tribe is providing those services, then really the state's only interest is in raising revenue. So when we're involving and implicating all of those detailed federal regulatory authorities and the tribal interests in expending for those services, that's shoring up that tribal interests supersede or outweigh state interests. So when we're looking at those other considerations, again, in any business venture, whether it's tribally owned or it is a partnership with a non-Indian owned business, really carrying that Bracker analysis into the planning room at the earliest stages is going to help bolster whether or not the state can eventually reach and tax that business. Another thing that I'd like to mention there is when we're involving or implicating the federal regulatory authorities or the tribal schemes, in a tribally owned business, you can directly tie that revenue to your tribal government, to supporting the services and programs for your citizens. So when we're looking at that, the burden becomes a lot greater if the state's taking away from the fund that is servicing your people, right? So those are just some other things to consider when we're going into that of how can we best prepare ourselves and our governments to win that Bracker analysis, or more importantly, and ideally, to be in the most strong position at a negotiation table with a state as it regards compacting. So that is what we have for dual taxation. And now we'd like to pass it to Imani, who is going to start us off on online sales tax.
Well, thank you, Sam, for that. So Hunter and I sort of tackled the online sales tax portion of the paper. And so I'm going to be talking about the case law about online sales tax, just generally, not in Indian country. And I'll touch a little bit how it affects Indian country. And I'll also continue and talk about sort of what Morgan mentioned, like a congressional approach to fix these issues. Spoiler, it did not pass, but I'll talk about that. And then I also will touch on another sort of tax compact / agreement that a lot of states are now using. So to begin with, e-commerce after the COVID-19 pandemic has boomed. A lot of people were stuck inside, so it's a $1 trillion industry now. And then in Arizona, the transaction privilege tax revenue has increased yearly since the Wayfair decision. And I'll talk about Wayfair in a little bit, but Wayfair allowed states to start taxing out-of-state remote sellers. And so Arizona in 2024 collected 18.6 billion in transaction privilege taxes, which is Arizona's equivalent of a sales tax. And so to start with a bit of the case law, I'm going to begin with the National Bella Hess and Quill. National Bella Hess was decided in 1967, and National Bella Hess was a retailer. They sold clothing, different types of apparel, and the Department of Revenue and the state of Illinois tried to tax them, but they didn't have any employees in Illinois. They were not based there. Their principal place of business was in Missouri, and so the Supreme Court held that National Bella Hess could not be subject to tax in Illinois because they did not have a physical presence in the state. And the Supreme Court said that the due process clause requires that definite link. And so they sort of equated the definite link to physical presence. And also they noted that it violated the Commerce Clause. But then after 1967, we see the Supreme Court start to develop a Commerce Clause analysis test. And so you see these 4 prongs come into being. And so the Supreme Court decided that a tax would survive a Commerce Clause challenge only if the tax, 1, is applied to an activity with a substantial nexus with the taxing state, 2, is fairly apportioned, 3, does not discriminate against interstate commerce, and then 4, is fairly related to services provided by the state. And the cases I'm going to talk about, including Wayfair, really focus in on that first prong, substantial nexus with the taxing state, which cues me into Quill. And so Quill happened in 1992, and so there's a big jump in time there. But if you had to take civil procedure as a 1L, you'll see that the Supreme Court started to develop its minimum contacts analysis for due process. And so they moved away from due process requiring a company to be in the state, to be sort of bound by the state's laws there. And they've shifted to a company can just have so much activity in the state to the point where it's doing as much activity as a business that would already be in the state or has its location in the state. And so in Quill, the court had noted that because its due process jurisprudence had evolved, that it no longer required physical presence in the state, but it noted, going back to that first Commerce Clause prong, that the sellers in Quill, which was an out-of-state, I believe, furniture seller, and they were also selling office supplies into North Dakota, they had noted that because they did not have employees in North Dakota, they didn't have a brick and mortar there, they lacked a substantial nexus. So again, the substantial nexus being physical presence in the state, and it didn't survive under the court's 4-prong Commerce Clause test. And I highlight here with Justice White, he sort of noted that more and more people were buying things online, or not online, it's 1992, but through the mail. And it was increasing in that the sales landscape was changing. And so he thought that the court should just overrule Bella Hess entirely and just get rid of that rule that physical presence is required for the first prong of that Commerce Clause test, which takes us to South Dakota v. Wayfair. So 20 years later in 2018, South Dakota v. Wayfair, which I'm going to refer to as Wayfair, is sort of the seminal case in this area right now. And the South Dakota legislature had noted that it was losing a lot of money from these out-of-state retailers because Quill had created sort of a loophole where a company, say I wanted to sell a lot of furniture into South Dakota, I could just not have an employee or brick and mortar in South Dakota, conduct tons of sales, and then not have to pay a tax, whereas a South Dakota company would then have to pay that tax. And so they passed a law. The law required out-of-state sellers to collect and remit sales tax as if the seller had a physical presence in the state. And interestingly, so the tax would only apply if the seller had delivered more than $100,000 worth of goods and services in South Dakota or had conducted 200 or more transactions with a delivery address in the state. And just hearkening back to those prongs, you'll start to see that South Dakota's legislature was really trying to make sure that the tax would survive under the Commerce Clause analysis. And so, and also just a side note, the legislature, when in its enacting legislation, had written that the tax only applied to the extent allowed by state and federal constitutional bounds. but they also put a note there asking the Supreme Court to reconsider that Bella Hess holding and the Quill holding. And so I put here, I just sort of want to emphasize the fact that the South Dakota legislature was really trying not to get its tax law struck down. And so I tried to show kind of sort of that prong of the Commerce Clause test and how they wrote or legislated the tax. So that first prong of the Commerce Clause test is applied to an activity with a substantial nexus with the taxing state. You have these provisions that require more than $100,000 worth of goods or more than 200 or more transactions. So we're talking about businesses like Wayfair that are conducting a lot of business in North Dakota, not your like Etsy seller shipping one or two things into the state. And then for that fairly apportioned prong, South Dakota adopted the streamlined sales and tax use agreement, which I'll talk about a little bit later, but it creates a uniform rule for tax administration and then does not discriminate against interstate commerce. They put language in the law that prevented or only allowed the law to be enforced to the extent it didn't violate the Constitution. And then fairly related to services provided in the state, we're talking about goods that are delivered to the state and services happening in the state. And so the court in its reasoning focused on that first prong, whether the tax is applied to an activity with a substantial nexus with the taxing state. And they said that the nexus exists when a remote sailor avails itself of the substantial privilege of carrying on business in a state. And so an entity like Wayfair applied to that. And so South Dakota sort of overturned this physical presence requirement. So now a company that's conducting a lot of business, even though they may not be physically in the state, can still be subject to the tax. And so, for example, in Arizona, they have the transaction privilege tax. I'm from California. If I'm, I don't know, a Wayfair and I'm selling more than $100,000, I could be subject to tax because I'm conducting a large amount of transactions within Arizona. And then the court remanded the case. So they only decided on the first prong. But like I said, the court sort of nodded to the fact that the South Dakota legislature had done a really good job tailoring the case to that Commerce Clause test. And so they left it to the lower courts to decide, though. Okay, and so the streamlined sales and tax use agreement. So after Bella Hess, and you have Quill in 1992, and then Wayfair didn't happen until 2018. And so you have this gap of these states, like I said, where these companies are sort of taking advantage of a loophole, of states losing a lot of sales tax revenue. And so the streamlined sales and tax use agreement was the product of 44 states, DC, local governments and businesses working towards the goal of providing uniform and simplified application, administration, and implementation of sales and use taxes. So when a state agrees to join the agreement, there's all these different rules about having like simplified definitions, a centralized taxing entity, only one filing requirement. So a local jurisdiction and a state can't have separate filing requirements, just different ways to sort of allow states to access this revenue while also not placing an insane burden on different companies trying to sell things across different states. And then Arizona is not currently a member state. There's 23 though. And then I have here just sort of, there's different levels of membership, but the full membership requirement requires a full compliance with all the streamlined sales tax rules. And then Morgan had mentioned a little bit earlier that Congress had not really acted, but Congress could act within its plenary power to address these issues. And so the Marketplace Fairness Act was that attempt. And so it was introduced in the 112th, 113th, 114th, and 115th Congress. And what the act did is it sort of integrated the language in that streamlined sales and use tax agreement. So the whole goal was to create uniformity across all the states for how to tax out-of-state remote sellers. And it had two options. It had one for member states, like I mentioned before, but then it also had minimum simplification requirements for other states that decided not to become a member. And those also were the requirements I listed of sort of having a centralized tax system, having a centralized place where you're filing, making sure your rates are very clear and available. And so interestingly, the last two versions of the bill included tribes as states bound by the terms of the bill. So a tribe would be just like a state required either to adopt the streamlined sales and use tax agreement or make sure that it's meeting those minimum simplification requirements. But these haven't passed, and partially what I think is why is because now you have Wayfair, which sort of opened up the ability of states to tax out-of-state retailers, but we'll still see. And then the last little bit I'm going to talk about are the Indian trader statutes and central machinery. So when we're thinking about online sales tax, I think the Indian trader statutes are particularly important because Indian trader statutes often preempt the imposition of state sales and use taxes on tribal members on reservation. And so the precursor to those statutes is the Non-Intercourse Act. The Non-Intercourse Act of 1790 prohibited trade with tribes without a license. And so the Indian trader statutes stem from that. And today the Department of Interior issues those licenses. And the original purpose of them was to prevent fraud and imposition on tribes. And so the Department of Interior, and I guess the federal government, did so through comprehensive regulation of trade on tribal lands. And we're going to discuss central machinery, but I just want to highlight that the holding in central machinery is limited to transactions where the tribal member or tribal government is purchasing goods and those goods are delivered on the reservation. They have little effect when the state implements a tax on a non-Indian purchaser or purchases delivered on a reservation. But when we're thinking of online sales tax, when we're talking about tribal members or tribal governments buying something and having it delivered on a reservation, it is important to keep in mind that there is that categorical exemption that my colleagues discussed. And now Hunter is going to talk about different state approaches.
All right, so just kind of building off of everything else that my colleagues have been talking about here, I was tasked with talking about some of the, I guess, more unique state approaches to internet sales in Indian country. So really the, I guess, considerations that states are faced with, especially when it comes to Indian country, really arise from how much Indian country there is within a given state. Some states don't need to worry about it at all, of course, because there is no quote unquote Indian country within a state. However, states such as, New Mexico, Arizona, Wyoming, and those states that have a sizable amount of Indian country need to consider Indian country in crafting these online sales and use taxes. So, just as an example, within the Ninth Circuit itself, it has around 80% of the tribal population, and Navajo Nation itself covers 27,000 square miles, which also intersects with Utah, New Mexico, and Arizona. So these create these jurisdictional challenges that we've been speaking of. One of the suggestions here by the National NCAI was tax parity between tribes and states themselves. And what I mean by that is that essentially tribes and states should be on a level playing field when it comes to taxing these transactions that are coming from out of state into their jurisdiction. And one could argue, arising from Wayfair itself, and I found interesting, is that if you have a transaction that actually bounces between one piece of Indian country and another piece of Indian country, one could argue that states are essentially closed off from taxing that transaction. So it presents really cool opportunities for tribes, and in considering, the future of commerce and e-commerce, it's something that's well worth considering, especially because, as we all know, that being able to purchase something online with the touch of a screen or a push of a button is becoming not the exception, but the norm. So another thing that also talk about here and tribes should consider, especially when it comes to compacts, as Morgan had mentioned, is that unlike IGRA, you don't really have any real federal oversight when it comes to entering these compacts. And so what you'll see in particular cases is states trying to leverage their authority in entering these compacts and trying to get tribes in exchange for tax revenue to forfeit aspects of sovereignty, including what they do or do not do with their land. So it's something to be aware of. So what is the economic nexus model? As my colleagues have explained, what's come out of this Wayfair decision is sort of a new test. And what other states have done is they've taken the holding from Wayfair and they've sort of run with it. As you can see from this map here, with the exception of probably 4 states, the vast majority of states have adopted an economic nexus model. And essentially what that means is that, say you have a remote seller such as Wayfair itself, and they sell over $100,000 worth of stuff into any given state, or conduct at least 200 transactions. That's what you consider enough economic contacts with the taxing state to impose their sales and use tax on that vendor. And as we'll see, a lot of states have actually starting to get rid of this 200 transaction threshold, to really give kind of a cushion for small businesses to not be subject to these taxes. And I can say that I think that's fair. I think a lot of larger retails would say that's unfair, but I think especially when it comes to small tribal businesses, that this presents a good opportunity, especially if they're conducting a lot of small, low dollar amount transactions with any given taxing state. I think it's a fair calculation on a lot of these states, and it's something that a lot of folks, when Wayfair came through, raised objections about because it did impose a burden on these small retailers. However, a lot of states have considered this and have acted accordingly in reforming their tax regime under the economic nexus model. So now I'll go into just a few examples of what some states are doing. And just as a side note, all these states, of course, have Indian country within them. And we'll see from it some of the different approaches and some of the drawbacks and benefits of these approaches. So first we have South Dakota itself. South Dakota has kind of a unique system that was unlike any of the other states that I researched in this process, in that essentially the tribal governments are exempt from the state sales and use tax when it comes to these remote sales. However, tribal members are not. One could argue that this does run afoul of central machinery and other federal legislation that sort of is supposed to preempt these state taxes. However, one of the big benefits of the state of South Dakota's regime is that whether it's a transaction between a tribe and a non-member, or even between a non-member and another non-member within Indian country, if they've entered a compact or an agreement with the state, there is just a single uniform tax rate applied to all those transactions. So, of course, what this creates is some legal certainty in these transactions, rather than having sort of a variable rate of tax between different remote sellers. And so what one could say that, of course, this runs afoul of central machinery, but so far, and from my research, I couldn't find that any tribes had objected to this regime yet. So I guess from that, you could infer that it's actually working for the tribes in the state. And of course, South Dakota is one of those states that's eliminated this 200 transaction threshold as well, to provide some cushion, as well as streamlining the process of collecting taxes from these remote sellers who have to remit back to the state. So at first, when I found South Dakota, some red flags certainly raised, but ultimately it looks like this 4.2% tax rate on transactions is actually working for tribes. In addition to that, and not seen on this slide, is that they also have an allowance for smaller, more limited jurisdictions for tribes that have only maybe a few particularly lucrative enterprises on the reservation, and that could be a casino, that could be a gas station, convenience store. So really, the way that I looked at these different schemes was from the vantage point of either a tribal business operating on the reservation, who may be selling things out of state, as well as a business on the reservation that's purchasing things from out of state. So especially within the context of those limited jurisdictions where you might have a casino or convenience store that relies on purchasing things from out of state, it's worth noting here that there is this just one size fits all 4.2% tax rate on these transactions. Next, we have the state of Washington. Like South Dakota, it's also eliminated this 200 transaction threshold that's part of the economic nexus. The one notable difference between Washington and South Dakota is that Washington actually expressly exempts, they've codified and expressly exempt these transactions that are by tribal members or tribal governments that are ordered from and delivered to Indian country. So whereas South Dakota hasn't made any exemption for tribal members themselves, Washington has actually codified that and recognizes this jurisprudence that we've been talking about today, which is super cool. However, there's always drawbacks. And I would say that the one drawback with Washington's scheme is, of course, the issue of dual taxation when it comes to transactions with non-members. And this doesn't have to be specific to just online transactions. You'll see a lot of different themes kind of pouring into different state schemes. One thing I found in my research was that Washington itself does allow for these compacts. And in one specific case with the Tulalip tribe, there was, I would say it was a particularly concerning instance of dual taxation where a federal court had basically ruled against the tribe for this kind of mall that was located on Tulalip tribal lands, and said that since it was non-member businesses operating on tribal land selling to non-members, that those transactions could be taxed. However, Tulalip and the state entered into a compact that basically said anything past this before this $5 million threshold, the tribe can just collect those taxes. However, as soon as that threshold is passed, then there was this additional condition that kicked in that basically required the tribe to contribute $35 million to construction of a facility on Tulalip tribal lands. So it's just worth keeping a note that when tribes do enter these compacts, that states, of course, are looking out for their own best interests and aren't necessarily considering tribal sovereignty and sort of the impact, having a tribe build a civil confinement facility, for instance, on their tribal land poses. So it carries trade-offs and it carries, some downsides as well. So Arizona has an interesting scheme. So like Washington, it also recognizes that these transactions emanating from Indian country by tribal members, as well as a tribal government, are non-taxable. They have something called a TPT. So it's a transaction privilege tax. And ultimately, my findings here is that this scheme, of course, is beneficial for tribes. Unlike South Dakota, tribal members are exempt when they purchase something from out of state, then that should be non-taxable. Of course, we get the problem of double taxation here in Arizona as well. Unlike South Dakota, something that was notable here was that in South Dakota, those taxes that were collected from special jurisdictions were actually partly given back to the tribe. However, here in Arizona, those taxes are not given back to the tribes unless certain other conditions are met. And so ultimately, 69.3 million in state revenue from tribal lands just in 2023 itself, with little revenue shared back to the tribes. This is exactly what we've been speaking to today, is the problem of double taxation. So ultimately, I think Arizona's scheme is beneficial to tribes. But of course, if tribes were to try to take it a step further and enter a compact for or an IGA, then they have to just be aware that, states are going to try to include these provisions that are ultimately more beneficial to the states and not to the tribes themselves. And lastly, we have Wyoming. Wyoming is a really interesting case. They have, of course, the economic nexus thresholds like the other states I've been speaking about. However, to qualify for the exemption in Wyoming, if you're on tribal land and you're a tribal member purchasing from out of state, you have to submit these forms to the state. And these forms are largely in accord with the SSUTA. In fact, I believe that Wyoming actually is a member of the SSUTA. But these forms have posed a significant challenge to tribal businesses and tribal members, really just cutting through like the bureaucratic red tape here, because these forms are confusing. There's if you look at the form, and I should have included a copy of them here, but if you're a tribal member, you're actually supposed to be checking this particular box, in it, and it's just really kind of non-intuitive. There's a particular box in the form that says, you're not a business. Supposedly that's the box that the tribal members are supposed to be checking. But anyways, the lesson here is that Wyoming's been trying to redress this problem through new legislation. One of the bills that they've been working on is actually dead as of right now, but ultimately, they're trying to get these wrongly imposed taxes back to tribal members and tribal governments. And something to note there is that Wyoming is actually trying to withhold the 1% of those taxes just purely for administrative fees. But again, whether that runs afoul of Central machinery or not is to be seen. So Wyoming just poses it's a good example of something that tribes should also consider. It's inevitable that taxes are probably going to be wrongly imposed on some of these transactions. So there needs to be some sort of mechanism in place to be able to cure that problem and get taxes back to tribal members and tribes in the end. So I have a little, just kind of a path forward section here, and what tribes, should consider moving forward. Either taking it upon themselves or working with states to come up with solutions. Like I've said, tribal state compacts are one possible solution to the problem. For the most part, those states with Indian country have done, hefty legislative fact finding and trying to figure out what to do about concurrent jurisdiction over particular transactions. And of course, one way that they've been trying to mitigate risks is through these compacts. So while they can offer clarity in some instances, of course, these can be used as sort of a tool by states to leverage over the tribes to get them to forfeit aspects of sovereignty, including land. So that's something that tribes should definitely consider, and I think tribes should also consider including provisions, in these compacts that acknowledge what the federal law is, acknowledge that these transactions by tribal members ordered from and delivered to Indian country should not be taxable by the state, and really just setting it in stone that, tribes are sovereign entity or they're sovereign nations, and that they shouldn't, be sacrificing any aspect of sovereignty just to collect tax revenue. Exemptions, trying to make it as clear as possible, either through codifying, law as well as through the administrative process, that, these same transactions we've been talking about are exempt from state taxation. As I've mentioned, some of these current processes can be burdensome on tribal members, and this isn't even considering some of the broadband issues that one might experience while on the reservation. So if you're going to expect a tribal member or a tribal government to fill out these forms and be constantly aware of the fact that they are exempt from state taxes. Certain things need to happen, such as, making the member aware that they're exempt from that they're exempt from the state tax in the first place, as well as streamlining the process and making it readily accessible to tribal members and governments. As with the case in Wyoming, like I've said, there's been a lot of wrongfully taxed transactions. So there needs to be some sort of either a grace period in place if they have not submitted the right paperwork, or some sort of easy mechanism to get that money back into their pockets. And one thing worth mentioning here too is, these tribally owned businesses and members should be aware of these private exemptions too. And so, for example, the Amazon tax exemption program is one example of a simple form that they can fill out and just ensure that that transaction ordered off of Amazon is not going to be subject to state tax. And one other thing I wanted to mention too is tribal ordinances specific to online sales. I think NCAI put it pretty succinctly in that, tribes should be really considering the way that their economies are going to look in this century, and not just be relying purely on states to take care of the issue for them. And so I think with legislative fact finding, whether that's through a tribal council or another entity with the tribe, is definitely necessary to sort of put a bit of like a bulwark between the tribe and the state, who might try to overreach into the tribe's lands. And so making it as clear as possible through ordinances that these transactions are not subject to state tax, that tribal sovereignty is a real thing and you cannot infringe upon it. It's incumbent upon tribes to do this. And so, tribes don't need to reinvent the wheel here either. And I believe Cherokee Nation, as well as Navajo Nation have already taken it upon themselves to start crafting this kind of legislation, or these ordinances that set out that these transactions cannot be taxed by the state. And it's just an additional way to make clear too to other vendors that this is the tax that you're going to be subject to if you're selling into our tribal territory. So, with the modern economy in mind, this is something that tribes should be considering. I just put a few examples of tribal member-owned businesses up here. Like I mentioned earlier, I thought about it from two perspectives in doing this research, which is, of course, the tribal business on tribal land that's selling to another jurisdiction or into another state, as well as the tribal member or tribal government that is purchasing from out of state. So we had Swinoma Shellfish Company. It's located in Washington. You can actually go online and you can, order their various products that are harvested from tribal land and then sold out of state. And so it's something for them to consider. What is the economic nexus in another state when we're selling out of state? How much are we going to be taxed? Are there exemptions that we need to be aware of? So on and so forth. Another example is Native Ground Coffee on Salt River. It's a business on Salt River Pima, Maricopa Indian community. Same goes for this member business as well. Just to be aware of the other jurisdictions that may or may not be taxing these transactions. How many transactions are they conducting? Shouldn't be too big of an issue unless they're selling, over $100,000 into another state. So just something to be aware of. And thank you.
So we just wanted to bring your attention to updates that impact tribes that go beyond dual taxation if you're not already aware of them. One of those updates is a recently passed regulation for entities wholly owned by Indian tribal governments. And so the Department of Treasury and the Internal Revenue Service, IRS, issued a final rule clarifying the federal tax classification of entities wholly owned by Indian tribal governments. The rule explains that if an entity is wholly owned by one or more tribes and organized under tribal laws, they will not be recognized as separate entities from their tribal governments for federal tax purposes. If you know what a Section 17 or a Section 3 corporation is, think of it like that. Additionally, the rule clarifies that these entities will be treated as instrumentalities of tribal governments able to make elective payment elections under Section 6417 of the Internal Revenue Code. So this provision is particularly relevant for energy credits under the Inflation Reduction Act of 2022, enabling tribal entities to claim energy credits more easily and directly. So as Sam mentioned before, there's different ways to make a tribal business, and this just codifies one way. The rule provides much needed certainty for tribal corporations incorporated under tribal law by clarifying that they will be treated the same as tribal government for federal tax purposes and will not be subject to federal income tax on income earned from commercial businesses conducted either on or off the reservation. The rule will reduce unnecessary administrative costs and reaffirm tribes' inherent sovereign authority. There's definitely more information on this in your material, so feel free to read up on that, look at the CFR. But with that said, as the saying goes, nothing is more certain in life than death and taxes. And unfortunately, when it comes to taxes in Indian country, it's about as clear as mud most of the time. So dual taxation of non-Indian economic activity on the reservation and how states pursue sales taxes from remote sellers raises concerns for the long-term success and well-being of tribes. We really hope today that you were able to walk away with something that we learned. Currently, tax issues in Indian country are analyzed on a case-by-case basis, which does not provide certainty for tribes and non-members looking to do business there. In the modern globalized market, tribes rely on non-Indian and non-member business activity to remain competitive, making these issues pertinent to tribal economies. We recommend that tribes maintain good relationships with state and local governments, understand the relevant policy discussions and solutions available, and plan practically on behalf of tribal interests. Thank you.
Right. Thank you guys for that amazing presentation. So right now comes the fun part. You guys have been sitting there patiently listening to all this information, taking it all in, and now we're going to give you guys an opportunity to ask some questions. So I'm going to go ahead and get a mic, and then we'll see if anybody has any questions, and then we'll also look online to see if anybody has any questions there as well. So by show of hands, does anybody have any questions that they want to ask or any comments that they want to make for our esteemed panel here? Yeah, we got one in the middle. Hold on one sec, sir. Because we're online, I want to make sure you have a mic before you ask the question. So I'll go ahead and bring this up to you, okay?
Good morning, everybody. My name is James Rivera, and I'm going to make a statement from the National Intertribal Tax Alliance board member. First of all, let me say congratulations to all of you for the work that you're doing. The information that you provided, you knocked it out of the park. I can see all of you here being, you know, the next group of folks coming up and protecting Indian country and fighting for the tax rights that we own. And we own tax rights that sometimes we feel like we don't. But when you fight really hard for the tax leverage that the tribe owns, you start to weaken the other side. and start to own that tax. And, I'm from a pueblo in New Mexico, and I have been on the forefront of fighting for, I initially started off in the gaming compacts, and then we went a little further into the dual taxation. And we created legislation in the mid 90s that gave the Tax and Rev Department the authority to negotiate intergovernmental agreements with the tribes that have been enacted since then. And we created a 75%, 25% split, and of course, 75 to the states. And as a vice chair of the Pueblo Tax Administrators Coalition, I've been trying to get tribal tax administrators to convince their councils that we need to turn that 25% into a single digit, because I use the example, if you have created $1 million in gross receipts tax, that is a class 2, which is a non-tribal tax or a non-tribal member tax. The state collects that, and they'll send you $750,000, and they'll keep $250,000. Now, does the state really need to keep $250,000? That's a question for each tribe to answer, but that, I feel, is a lot of revenue going back to the state that should stay on tribal land. However, through the process of being involved in the state legislature and doing government affairs, we have been able to work other deals with the state of New Mexico, where other revenues through other tax sources, like the severance taxes, and through the general fund taxes that come towards the tribes through capital outlay and tribal infrastructure projects. But my point is being involved, getting involved with your tribal government as a tax administrator, and educating them on of course, the taxation, but you need to get to that state legislature to start talking about tribal taxes and fighting for your tribal taxes to remain on tribal land for this tribal governments. And once again, congratulations to all of you. Thank you. I really enjoyed your presentation.
All right, thank you for those comments. I know we have some tribal tax administrators here in the building. Did any of you feel like you wanted to say something on things that you guys are doing on your reservation that maybe the conversation sparked in your mind, or maybe thoughts that you might have from the conversation? Or any of our students? I know we have the economic development class in the house too. Welcome, economic development class. Here we go.
Hi, good morning. Good afternoon, everyone. My name is Effie Ed City. I'm the executive director for the Navajo Tax Commission. I was forwarded the invite here. I'm very happy to be here. Very glad to be here. That was a great presentation. Half of that is just almost everyday battle for me. All the issues that were brought up and the different ways of trying to solve it. We're talking about IGAs and compacts. Those ideas and thoughts have crossed my mind. I have documents on my desk in reference to those. But one, we have a controller for the Navajo Nation, Mr. Sean McCabe. He's unfortunately not here today, but he is, instead of going after an industry as a whole, right? He actually was able to negotiate with one business alone. So I'm wondering if that is an avenue that as tribes we're going to have to take, if we're going to have to take one conglomerate at a time and create agreements with each one of those instead of the whole industry, instead of just like a borderline $100,000, right? Or 200 transactions. Maybe it's just an idea and a thought that we're going to have to do one business at a time. I'm not sure, but Navajo Nation right now is negotiating with Amazon on that. And that's mainly for purchases for the Navajo Nation government. We do cover 3 states where we're on the larger side on that end as far as purchasing. So it may be something worth thinking about, just outside the box. We're going to have to try to get these revenues one way or another. And being executive director, I probably have about a good 11 years experience with the Navajo Tax Commission. And coming back as director, I really take a stance on sovereignty. And as a lot of people know who have been in any of my meetings, I will fight for every penny for the tribe. Believe me. And so that's my stance. That's where I'm coming from. I'm not giving up. Not a penny. I'm not giving up sovereignty here. We're going to fight for this taxation dollars. It supports the tribe. It goes right back to the tribal members. It goes back to the elders. It goes back to children. It goes to education. There's a lot of issues and situations that we deal with, socially, economically, and we need to fund those. So that's just a thought, just an idea I throw out there. Maybe it's going to be have to come down to an agreement with conglomerates and one at a time. I'll just throw that out there for thought.
Appreciate it. Thank you for those helpful tips and advice. Does anybody from the panel want to respond to any of the comments up there?
I just want to say thank you for bringing that up. I used to work in the philanthropic space, and in the last 5 to 10 years, we've really started to see a lot of movement in public-private partnerships between tribes and larger corporate businesses and their philanthropic arm. But moving that or building on that relationship to then move into a taxation agreement is really innovative, and I really appreciate you sharing that with us.
Okay, any other questions from the crowd? If not, I think we have some questions in the Q&A chat. But I want to see if there's any questions from you all real quick before we go online. Not seeing any. Let's go to the Q&A real quick. So we have a lot of congratulatory remarks. So good job, guys. Appreciate it. So Allison Ball, she says that they have a fuel state compact where they agreed to only use state-approved distributors. They recently began purchasing from a neighboring tribe that doesn't collect state taxes. Aside from their compact, does this put them at risk for paying the state fuel taxes that they're collecting from the other tribe? That sounds like a very technical question. And so I'm going to see, does anybody, Professor Irving, perhaps do you want to look at that question or not?
Going back to the disclaimer, we do not give legal advice as part of this presentation. But I would say it certainly puts them at risk with their own compact, depending on the terms of it as to how broad it is as far as who they sell to. So that's what they have to look at first. Does it put that at risk? To the extent the tribe is buying, the fuel for its own use on its own reservation, probably not great risk associated with the fuel tax. But then the question is, are they selling it on to anybody else? But again, that's not legal advice of any kind. So, but I think it shows the developing nature of it. And I will make one comment about negotiating with Amazon, on a company by company basis. That's been the Amazon business model for decades. And I'm not maligning Amazon in terms of it's wildly successful, but it took advantage of Quill and structured its business to not pay sales tax. And then, but as they developed nationwide, they had physical presence everywhere. And so they would wait to be audited, and then they would negotiate a deal promising to pay forward, but get out of all back taxes. So the business by business negotiation may actually be necessary. And that's the model that they've shown for decades. So.
Appreciate that, Professor Irving. You've allowed me to analyze the queue a little bit more. Robert Anderson says, does the fact that a PL 280 state provides some services in terms of concurrent civil jurisdiction for state courts and the provision of criminal law enforcement affect the BRCA analysis? Are there any cases that address that issue? By the way, this is an excellent program. Good job, guys. So in your research, did you guys find any instances where PL 280 factored into a BRCA analysis?
Absolutely. Yes, and it's any state services, any state jurisdiction, all enter into the analysis.
Yeah. So Professor Irving, I'll let you go ahead.
I think any state services that are provided, any state jurisdiction allow. That's why it's counterintuitive, but to me, the most important tax case in U.S. history was always McBratney back in the 1800s, finding the states have criminal jurisdiction over non-Indians on reservations, because that opened the door to states having jurisdiction on reservations. And if states have jurisdiction to impose law, that opens the door to collecting revenues to pay for the jurisdiction. So, you know, there is no silo saying taxes are here, everything else is there. The law and the Supreme Court mix everything. So to the extent there's ever jurisdiction overlap, including Public Law 280, it will absolutely enter into the BRCA analysis. So.
Thank you. Thank you, Professor Irving. I think we should just have you keep a mic. So we have another question here. Joe Keene, welcome Joe Keene, an alumni of this illustrious law school. He asked, on imposing a tribal tax on non-member activity within fee land within the reservation, does the Atkinson Trading Company case basically foreclose this option? Any thoughts on trying to successfully impose this type of a tax? So again, with the disclaimer on not providing legal advice, I think the Atkinson case is interesting for a number of reasons. But one of the reasons why I thought Atkinson was interesting was because they applied the Montana test. Because the activity took place on non-Indian fee land within the reservation, the court thought it was appropriate to look at that through a Montana lens, so not necessarily a BRCA lens. And so this distinction of land, I think, was very telling with respect to the Atkinson trading case, trading post case. And so for me, it seems like maybe a potential way to get at those fee lands within a reservation might actually be the compacting process. If you guys can agree to terms within a compact that define lands such that they would include businesses on fee land within a reservation, maybe perhaps that gets you there. But as far as the case law is concerned, I think Atkinson was clear with respect to how you treat non-Indian fee land within the reservation. Is that consistent with you guys' research? Okay. Professor Irving, what do you think? Anything else to add to that? No? All right. Now I'm going to go back to our crowd here. Do any of you guys have any questions? I have my pedometer on, so I really want to be able to walk up and down stairs and come to you if I have to. Yeah? Oh, we got one in the back. Ronnie, I got you. You're right up.
I'm kind of targeting Sam with this question. So we talked earlier about how there can be reciprocal, like temporary tribal membership. Could you talk about how states might try to litigate that and what protections tribes could assert in court?
So a little background. Last semester, I did a paper that was kind of exploring intertribal agreements for tribes with bordering jurisdictions, and whether or not maybe an intertribal agreement could work as far as regulation over energy projects and things like that. So kind of building on that, we were talking about, well, could that maybe extend to taxation for non-member citizens living on a different reservation, or what does that look like? I think it really remains to be seen. And that would be one with, as we're seeing more intertribal agreements build out around like reciprocal agreements, for example. The Intertribal Council in Oklahoma recently did an intertribal agreement over hunting and fishing license. The details there are essentially a citizen of one tribe could hunt and fish in the jurisdiction of another tribe without needing a state license, but reporting to the tribe whose jurisdiction they're in, and then the tribe to which that citizen belonged then kind of recuperates in whether a license fee or something similar. I think as taxation goes, it really gets kind of hairy because at this point, the case law regarding non-member citizens is pretty clear. So you get back into that analysis of kind of what services are being provided by whom and kind of that. So I think right now there's not really a strong case for it, but maybe that's something that tribes want to explore and figure out.
One follow-up and then we'll go to Dean Leeds.
Garrett, could I add something on that?
Yes.
If this works, if that works, just add something on that. And I think Sam's absolutely right in terms of the case law being really clear. But this is the time where we're talking generalities here. And so it may, you really want to look at the very specifics for the reservations and the tribes as to what their creating documents are. And my example is from 30 years ago, there was an Arizona had a tax case, an income tax case involving somebody who lived on the Colorado River Indian Reservation and actually worked for the Colorado River Indian tribes. But she was a member of the Kashan tribe, which was a nearby reservation. And under the law, she was a non-member Indian. So the Department of Revenue tried to tax her. But they pulled up the creation documents for the Colorado River Indian Reservation, and it said it was set up for the tribes of the Colorado River, the members of the tribes. And that was sufficient to overcome the non-member Indian analysis in the case law because the reservation was set up for her group, even though she was not a member of that particular tribe. So look at the underlying documents, statutory treaties, executive orders, whatever they are.
Follow up to that, could a tribe share its tax immunity with a complete non-member, non-Indian?
Well, specifically under the rule that I was talking about, the entities wholly owned, it's got to be one under tribal law, and it's got to be one or multiple tribal governments. So you can't have a non-Indian be a part of it, at least under that rule in particular.
To add to that, there is case law though that looks specifically when we're looking at like partnership agreements, right? Of how much of that company does the tribe own? So is it 51% or more? But within that, some of that case law has really reached in to see, well, are you just a partner in name or are you a partner in practice? So they look specifically at is the tribe in a position within the company to be making day-to-day management decisions? Because if not, then you're a partner in name. And so the kind of tax break is not applicable. And please correct me if I'm wrong on that. But so I think when it comes to that, the only situation would be in a situation where going back to like strategic business structures, if the tribe is going to partner with a non-Indian business, you would need to assert that 51% ownership and also reserve spaces within the daily operation of the company for tribal members to give the tribe some control over those decisions as well.
And I was also going to remind us to look back at all of the treaties, not just between the United States and a particular tribe, but between two tribes. As Professor Irvin mentioned, where you have treaty relationships that involve multiple tribes for different purposes, there is a provision in the last Cherokee Nation treaty with the United States post-Civil War that says that tribal citizens in their commercial activities are not even subject to United States taxation until the commercial activity leaves Indian territory, specifically mentioning all 5 tribes. And I think that's a treaty provision, not as to the tribes, but as to individuals that have commerce with each other in those 5 tribes. So take into consideration a supply chain that goes Cherokee to Muskogee Creek to Choctaw, and only when it goes to Dallas does it become a taxing event. And so there's United States precedent, Supreme Court precedent in cases that involve even Public Law 280 states, like the Menominee example. That's a hunting and fishing case where even after the United States had terminated its relationship with the tribal government, the court said that the hunting and fishing rights of the individual descendants of the people of that treaty are still intact. So if you have treaty language talking about commercial activity and taxation, think about that impact on the individual as an individual entrepreneur, in addition to the way that we think now about tribal businesses.
All right, thank you. And just a quick look at the time lets me know that we're almost at time. So I want to give us an opportunity to say some closing remarks. I, for myself, will say it's been a pleasure and a joy teaching these students about this issue. I think they've taught me more than I've taught them. I'm really happy with the result and with the presentation. I'll say this issue is very important because of the situation that tribes are in. Tribes don't have the same opportunities to tax property like other jurisdictions do. Stateside, you can have property taxes, which account for a sizable portion of their revenue streams. Also, tribes don't apply income taxes to folks that work on their reservations. So it really hamstrings them as far as developing tax revenue to provide government services to their communities. So tribes oftentimes rely exclusively on tax and economic activity, sales tax, other types of activity to make up their bottom line, as well as with Indian gaming. We all know that Indian gaming is successful for a handful of tribes, and then it also helps supplement a lot of incomes for other tribes as well. So it's not the end all be all. So for us, this is an important topic, and I'm glad these students were engaged and interested in it. But I want to go ahead and pass the mic down to you all, and you guys can say a few closing remarks, and then we'll end this program. So.
Well, thank you everyone for coming, and thank you to Professor Beetso. As you mentioned, Morgan and I realized how important taxes were for Indian country, just knowing different tax systems, and we were a bit persistent. So I appreciate him well, actually, I don't know how asking for a class turned into drafting a paper and doing a presentation, but for being willing to sort of foster this interest for us. And so thank you.
Yeah, I would just like to thank Professor Beetso. I think just being up there, I was nervous, obviously, but I'd encourage everybody to read the paper if you have a chance. There's a lot more in there, and even that is just barely scratching the surface, especially when it comes to online sales. It's such a new thing that it's just we're kind of at the headwaters as far as its a legal development, and so it's something I'm super interested in now, and I was never even aware of Wayfair until we got into this course. And I think it presents a huge economic opportunity for tribes. And it's well worth exploring, or at least planting the seed with tribes, because as we all know, being economically independent depends on these tax revenues. So I would encourage everybody just to read the paper. Thank you.
I just want to say again, thank you all for being here. Very big thanks to Professor Beetso for kind of shepherding us along this journey and extending that thanks to all of our faculty in the Indian Law program for always encouraging our curiosity. I also want to give a shout out to Salt River Pima Maricopa Indian Community Office of General Counsel and my wonderful mentors there for always entertaining my rabbit hole questions.
Just want to reiterate everything that the panel has said already, but thank you guys for listening to our presentation and giving us the opportunity to explore it. And also thank you to ASU. You know, they're always great with fostering these types of somewhat niche, but also very pertinent questions in Indian law and always supporting that. And so, yeah, also a big thank you to Professor Beetso for entertaining the Indian tax class cluster.
As everyone's mentioned, thank you for being here today in person and online. Again, like Amani said, didn't know how this class turned into a paper and a presentation, but here we are. It was one of 4 classes I had with Beetso this semester, so you're done with me for one. Congratulations. But again, Pinagigi, thank you for being here.
Right, and Mr. Irving, last but not least. Just did it.
Thank you, and thank you to the students. It's a great job. Congratulations.
Okay, so for those of you online, you should receive an email within a week with a recording of this presentation. For those of you in person, we usually post presentations online on our website. I really appreciate you guys coming out. We hope this information was helpful and fruitful for future discussions. And just thank you for your time and your interest. Really appreciate it. Thank you.